Very good evening to all of y'all. I welcome y'all today to the drafting marathon. Now, this lecture is going to cover around 30 to 40% of the paper that comes in your 30 to 40% of your question paper. So, how is it possible? And I can tell you this is the reason why I have taken the first part of drafting these topics. So, what are you going to teach today and how it is going to help you in your examination? As a student, I know since the time is very less, you need to know certain things, and those things I will be taking first. So, let's begin what I will be doing. Before I start, can I have in the chat section GTG, good to go, everything is clear, so I can start. So, what I plan to do in the first part of the marathon is to teach you every single draft from the module. Sir, how is it possible that I can teach you? I guarantee you, if you sit till the end of the session and don't try to skip any part, you will be able to easily attempt every single drafting question that comes in your examination. So again, I had cleared this drafting exam with very good marks. I have won some drafting competitions also, and I am going to reveal everything to you. Now, before I start, what I have done is I have made certain draft formats for each type of agreement, deed, code formats, everything that comes in the exam. Okay, and it is accessible for you for free of cost. Go to our website Jahangir Tutorials. There is free section. The draft formats which I will be teaching from today is available to you. You can download it. I think around 1000 up students have downloaded it and are studying from it. Okay. Varun, Dev, Sudalia, great. Okay. Let me know in the chat section if I'm audible, visible, and we can start. Okay. Now let me tell you in the exam question, including the exam question of December, December 2024, June 2025, they've always asked drafts from these types only. Okay. So the following draft question formats are asked in exams, are asked in exams. Wouldn't you want me to tell you which draft format comes? And not only that, I will cover it for you. Okay. So that you never have to worry. And after that, any page of the module you open, you will be able to draft it easily. So your drafting questions come from 4 categories. Your questions are faced from 4 categories only. Okay. Great. Kajal has already downloaded. Great. Let me tell, I hope every single one of y'all, if you're attending this marathon, it is useless if you don't have the document from which I'm teaching you. Okay. Wrinkle, great. It'll be useless if you don't have the draft format that I'm giving you, which is a very big gift. Okay. So the very first one in the exam, they will ask you about agreements and deeds to draft. Agreements and deeds. Great. Dave, great. I'm glad it's open. Second, the type of agreement, second that comes, the draft of question, and this comes for around 30 marks and sometimes 40 marks in the exam. So instead of worrying about the drafting paper, sit for this and I'm going to beautifully cover where you will understand from the practical aspect as well. I will be showing you practical drafts. I will be doing every single thing required to get an exemption. Okay. Now, first thing is 30 to 40 marks I'm going to cover, and I'm covering the draft format that are asked in the exam. And if you've given an exam before or you see the past attempt papers, all the draft format that I'm giving now are all covered. Okay. Second, very important thing is first they ask agreements and deeds. Second, they are asking anything about code formats. Okay, code formats. So a code format could be a format where your M&A agreement has gone to NCLT or operation mismanagement. Okay, so any type of code formats can come. That's the second thing. Third, sir, what is the third important type of things that they ask is letters. Okay, some kind of letters they ask Okay, like write a letter to the director, write a letter to the promoters, write a letter to the shareholders, etc. This is the third one, and the fourth one, what they ask is related to even in letters, and practically this is what I do. So I will show you also. Will you make this session private after it ends, Kajal? No, I will not make it private. But remember one thing, finishing it with me, you will really finish it. Otherwise, there are videos and you will never end up reading it. So better sit with me. I won't take too much of your time. I know as a student, and it's very important. That is why my lectures are extremely to the point. Okay. Now, next, in that they are asking not even to write letters, but they are also asking show cause notices and to reply to show cause notice. So what do you mean by that? So for example, as a lawyer, so I'm even an advocate, so we send legal notices. So legal notices also how to send it, and my clients receive legal notices also, so we have to reply to those legal notices also. So there are some principles to be followed in sending legal notices and receiving legal notices also. So that also they ask in the exam. And the fourth one are miscellaneous other aspects such as bail and other things which are there. Okay? So all your exam questions will come from here only. In the June 2024 exam, they had asked to draft a mortgage document. Okay, mortgage. Now you don't have to sit and learn draft of anything. I'm going to teach you one format for each one, which you can nicely place it in your examination, and the legal principles, legal requirements. Because if I am a corrector and I look that this legal requirement is not put, in case of power of attorney, certain keywords are to be put, and you've not mentioned it, you will get marked down heavily. Okay, so are we good to go? Can we start? In my first part, I'm covering this. So everything will be covered. So today, every single draft format, and it is my guarantee to you. And we will counter check also. We will open any page of the module. I have the module also in front of me. I'll just randomly go. You all will tell me in the chat section to stop. Whichever draft it falls, I will show you that I have covered that draft as well. So how is the challenge? So I'm saying after I complete teaching you, I will tell me the page number on the drafting. We will go to it, that kind of draft. All the drafts of your module will get over after this lecture, and 40 marks of your examination which comes for pure drafting will be secured. Concept clear? Yes or no? Everyone excited? I won't take much time, but I need your continuous participation. Sir, other 60 marks will be theory? Yes. Other 60 marks will be direct theory. Direct theory questions for which you have to study and write. Copy, paste, copy, paste, copy, paste. But 40 marks will be proper drafting. So open your June, or you see the guideline questions. They have directly tell you draft XYZ agreement, draft this letter, etc. So these are direct. Draft a bail application. As I showed you this part, even bail application they have asked in the June 2025 examination, and I told it is important, and all these categories as well. Okay, so let's begin. Can we start? Yes or no? GTG in the chat box, and I will start teaching you all the entire draft formats. I require you all to be in a secular place. I know these are online lectures. If there can be distraction, there can be a lot of things where you lose interest, etc. because of the distraction. So keep your mobile phone aside. Sit in a secluded corner, book, pen, sit with me, and after 2 hours you will thank me, and it will be the most precious 2 hours of your life. Okay, with that you dedicate for drafting. Okay, Dev great, Vaishnavi great, Wrinkle great. Let's start. Prerna cool. Nice. Let's begin. Hi. So we'll be starting with the draft formats, and in the draft formats I'm going to cover every single draft that has been asked or can be asked in your examination, and to verify it, after I complete the lecture, we will go through the entire module and see whether I have covered or we have covered all the drafts and whether we are capable of drafting any kind of situational question or draft presented before you. So first I'll be doing the agreements on how you can draft agreements. So basically there will be two parties have agreed to do something and we have to present it in a draft format. Second is there are two parties fighting with each other. So when they fight with each other, they go to court. So there will be a court, there will be one plaintiff, defendant, and it will have a different format. That is why I've kept it in category 2. Category 3 is when you are asked to write a letter to the bank, you asked a letter to write to the promoters, to the shareholders, etc. So the format of letters is different. And fourth are miscellaneous drafts, which are some here and there drafts that keep coming, like a bail bond application that is to be filed. So all these exam questions will and has to be formed from these categories only, and we will be doing all in this lecture. So let's begin with the first one. Now in the first, what we will be doing, we will be looking at aspects of court. So these are all court related drafts. Now you tell me that an agreement where there is no dispute involved will be different from a petition drafting for court, because in court you will have the court, the name of the court, the case number, the whether it is criminal, civil, accused, plaintiff, the wordings and the formats change completely. So the first one that we will be looking is the court formats. Clear? Yes, sir. So after this, any kind of application, I have personally appeared before NCLT also. Okay, so I know the drafting petition of NCLT, and all the practical work that I have done, I will be taking you through here as well through my drafts that I have incorporated here. So one is a plaint, that is filing a petition or a complaint. What a complaint is in criminal cases, plaint is in civil cases. Okay, so this will be in civil cases. You go to the court. Like for example, I want you all to let me know in the chat box which kind of applications can go to NCLT. Come on, I want you all to think as well, like in a courtroom when I walk and go, or if you've ever been to any NCLT, I walked in, I see the majority particular cases are of oppression and mismanagement cases. Second, I have seen matters of IBC where one company could not pay the money and the bank is filing a case. So this is a case of plaint. We'll see the format for that. Then if the judgment is passed and you're unhappy with NCLT, then you go in appeal to NCLAT. That appeal format will be differently worded. Yes, sir. So obviously going to NCLAT, but from NCLAT also, if you're unhappy, you go to Supreme Court, right? You're even entitled to go to Supreme Court. Now my question is, when you go to Supreme Court, you have to file something. What is that thing called? Everyone, when I want to, when the High Court has passed a judgment, or I want to go from High Court to Supreme Court, there is a word that is there which is called as special leave petition. What it is called? Special leave petition. Sir, what is a special leave petition? Like, it's not a garden that from High Court I directly go to Supreme Court. It's not a garden. It's not a right that you will directly go. There is a procedure to be followed, that you require a special permission from High Court, that you telling the High Court that listen, this matter is fit to go to Supreme Court. A legal matter is involved. It is a matter of legal ponderance or legal inspection. It is a matter of law that needs to be decided by the Supreme Court. So then they will give you, and in some cases I can go directly to Supreme Court saying that High Court is not allowing me, you please take me. So is the concept of this clear first, that what is a plaint, that is filing a first, then if your judgment comes against you, then you have to learn how to file an appeal to the appellate court. And in the end, during this entire thing, there could be criminal cases where a bail application is filed, where someone's in jail. So I have also filed a bail application. And luckily, let me tell you, the accused was also released on bail. Okay, so I have taken a sanad, so I can appear in court as well. Okay, so I have appeared in criminal courts also, so I will be taking you through all of them. Clear till here? Yes or no? Let's begin. Now we'll be starting the format for plaint. Okay, format for plaint. Very, very simple. Now, first and very important thing, my question to you is, and this is what students normally get stuck. Sir, do I have to assume facts and write the name of the court at Mumbai, serial number? Should I put or should I leave blank? I want you all to tell me that if in the exam question, in the exam, they have asked a question that draft a plaint for operation mismanagement. Okay. Now you have to write the court, you'll have to write in which state it is there, you'll have to give the name of the suit. Okay, all those things need to be mentioned. Will you assume the facts or leave it blank? Come on, quickly tell me. If in the exam they tell you assume facts, then you assume the facts. But will you assume facts or you will leave it blank? I want all of you all to write in the chat box. In the exam, when they ask and they have not told you to assume facts, will you leave all these entries blank? Like, you know, when they give the name of party, so you'll just write name of party. You will not assume, like ABC Limited, I'm assuming the name. But what we'll write, name of party, or we can write name of plaintiff. Will you write that or will you write the blank? If they have given you the name of the company, and you will obviously use the name of the company, but I'm saying if no facts are mentioned, will you assume facts or leave it blank? Quickly. Very, very important. Okay. Qadir Sultan is saying you will leave, assume facts. If the facts are given, then only, otherwise leave blank. Very, very good, Dave. And Mr. Qadir Sultan, please remember, you cannot assume facts if they've not told you. Don't assume facts, leave it blank. This is a very big mistake. While writing the paper, students don't know what to do. Okay, so what you will do, you will leave it blank. Exactly how this is. Understood? Yes or no? So name of parties, address of parties, things which are factual will be left and not legal will be left blank. If not, then blank. Ritika, excellent. So one thing, we are all on the same page. If facts are given, we will assume it. Or if they tell you assume fact, then we will assume. Otherwise, we will leave it blank. Sir, how you can be so sure? Open the model answer of ICSI. I see the model answer and then I speak. Chalo, let's move ahead. Now, format of plaint. Now, before I start teaching you format of plaint, I want all of you all to put in the chat box, even if you're watching this lecture later on, you can't put it in the live. I want you all to put in the comment section. A plaint could be filed in NCLT for what? What all matters? Or any kind of criminal, civil, etc. I want to know what kind of cases do you think can come? Only when you think, you will come to know, you will be able to relate. And then I will tell you where I have filed a plaint and in what matter. Chalo, tell me. All of you all have to use your fingers and type. 2 hours, I'll make you a mastery in this is my guarantee. Okay. You have to dedicate your time to me. Mention in the chat box. I will be reading every comment. What kind of matter can go up in court that it would come? Assume a situation and tell me that, XYZ situation can come up in court. Clear? So then I will tell you what matters I have dealt. Okay, or what matters normally can go up. I'm reading quickly. Let's see. Quickly, everyone has to put in the chat box what kind of disputes can go in court, whether it be civil, criminal, etc. Because question will come like that only in your examination. Quickly, if nobody is typing, I want you to type. So I'll give you examples. Okay, so what is a complaint? Complaint is in criminal matters. Criminal matters. Plaint is in civil matters. Okay, now we are talking of complaint or criminal matters. Okay, what kind of matters can go? Examples. Okay, any kind of disputes will go. So let's take an example, some which I will give you as a company secretary. What comes to us? So there was a case where a director was removed from his post and he wanted to fight the company. The director was also the shareholder of the company. He had around 15% in the shares. So the director was removed and he came to us and we told that you have shares. Yes, he said I have 15% shares. We told him you can go under operation and mismanagement. Now you need to know the section number. Operation mismanagement is the most classic asked question in the exam. Most commonly asked in the exam and in the NCLT real life practice also. I want you all to tell me the section number of operation mismanagement. Quickly, tell me operation mismanagement section number quickly. Very good. Dev has said suit for specific performance. I'll come to that also. Krishna is saying IBC matters. Very good. I said operation mismanagement is the most common. What you all have said is not that common. Of NCLT, you enter your any day, you will see the cause list. Operation mismanagement has to be there. I want to know the section numbers. Very good. Excellent work, Ritika. 241 to section 246 deals with your operation and mismanagement. Very good. Okay, now coming to the next one. Next most common second thing, okay, is your IBC matters, insolvency bankruptcy code. Now this also matter we had done as a company secretary. We will normally, so let's say there will be a bank. Here also I have appeared, okay, under section 7. Bank is there. Now bank has given a loan to, let's say, a company. So bank is the lender or called as a creditor and the company is the borrower. Simple little points, right? Simple stuff. Now the company, one is a bank and the borrower is the company. Now my question to you is, under which section of company IBC code the matter will be placed in NCLT? Sir, is section number important? I am going to tell you the most commonly asked so that you have to write the section number. Okay, so it is in section 7, 9 and 10. In 7, 9 and 10. In 7, whenever there is a financial creditor filing a case, and this is of IBC code 2006. Clear till here? Because if you see, if you don't write the section number only of the most common things, how can you even expect a marks? Okay, because your competitors are going to study everything and you will be that competitor who's going to knock out everyone. So whenever a financial creditor files a case, it will be in section 7. When a operational creditors are, what do you mean? A supplier or employees, when they are there, those who have provided goods and services, they have give loan, debt, direct money they have given, financial creditors. Operational creditors have given what? Service or goods, they can file. And in third case, the corporate debtor himself files a case that, listen, I want rehabilitation, so I am filing a case in court. Clear till here? So this will be their IBC cases. Any other case? So these are the most common cases that come before court. Okay. Now the third one is also there. Section 9, very good. Okay. Section Ritika, very good. Third most common case, not only in NCLT but in exam also. This I don't know how you all don't know. Have you all not analyzed past exam papers? I have given the scanners also. The scanners are available on free resources section of our website. There I have told You all have to tell me which is the third case which is repeatedly asked in exam as well as in practical life. In NCLT, what matters will go quickly. So the third kind of matters that go before NCLT is merger and amalgamation. What is it? Merger and amalgamation. Obviously, company A and company B, they have made a scheme. So scheme of M&A, that is also presented before NCLT na. Now you all have to tell me that this scheme of M&A is under which section of Companies Act? Very good, Krishna. So it is your section 230 to 240, and most actually the section you could say is 231. Okay, 231, 232 are the real processes. So these you need to know. Concept clear? Yes or no? Yes, sir. In case you can't remember the specific section for fast track merger, specific section for your section for cross border merger, then in that case you just write the section range, section 230 to 240, you will be good. Very good. Okay, so these are the three most common plaints that come in your examination. Okay, and any paper you open up, your exam questions will be framed from these three only. Okay, from these three only. From these three only. Open the past exam papers and you will say, sir, you are saying is right. Now coming back to the learning the format. Now I'm going to teach you the format and you will learn it once and for all. Now whenever they start, you see in the quote of dash at dash. So what is it? I'll tell you what it means. I'll take you through a real life draft also of a code format. Let me see. Just a sec. So what are we doing, sir? What are you doing? I'm going to show you a practical life draft. Okay. Now you see here a practical life draft. Now in this, can you see this? Now this is a real life court case. Okay, real life court case. You see in the court of, it always starts like that, add this and the application number is given. So you see here what we have done. One is this and the other one is this. Okay. So in the court of, you can write judicature, okay, of NCLT Mumbai, or in the High Court of Judicature at Mumbai or Delhi, wherever it is there. Okay, so you can mention that. Describe the court. Judicature at Mumbai. This will be your introduction of the court. You have to introduce the court. Can you see this? In the Court of Sessions, Mumbai. This is very, very important. Okay. Now, if I also see another court format, any format you see, in the Court of, so you have to start in the High Court of, just write in the High Court of Mumbai or at Mumbai, in the NCLT of Mumbai, that is fine. Then the very next thing you will write is the suit number. Is the suit number. Sir, if I am filing the plaint, how will I get the suit number? Can you see this? Now, if it is a criminal case or a civil case, you have to mention civil suit number this or criminal suit number so and so. So when you take your plaint as a lawyer, let's say you drafted your petition for your client, you go to the High Court or the NCLT registry. The office is there. You give them your application, they will look at your application whether all the stamp duty is paid, court fees is paid, you've given how many copies are required, proper CD has been, soft copy has been given. After being satisfied, then they will give you a number, case number. So you will mention a case number. Now you have to leave it blank, and normally it will always be linked to the year, right? Then you will write whether it is of original jurisdiction if it is first time. If you're going in appeal, you will write a appellate jurisdiction. Concept clear? Okay, so they will mention that, and then you'll write in the section of 230 of Companies Act 2013. So this is very, very important. Before even starting what the case is about, this format is fixed. Is this clear? Yes or no? So this is mandatory to be written. Next, let's start. Okay. Then you will write the name of the parties. Now, see the name of the parties. Whatever it is, you will write, since it is a civil matter, you will mention the name of the parties, the address. If it is a company, then the registered office, and then you will present it as plaintiff, right? Plaintiff. If it would be an appeal, you will write appellant, then versus whoever is the other party, and defendant. Concept clear? Yes or no? Now one more thing is there. As I told you, these three comes. There's a fourth one also that comes. The fourth one also, which is a special leave petition. Okay, that is under section 134 and 136 of the Civil Procedure Code. Okay, so special leave petition is also very important. Here you will write under the Supreme Court, and then you will write the special leave petition number, right? And then the name of the parties, party A, your plaintiff versus the defendant. Now see the language in which they start. Always this language has to be put. Now how do I start? For example, I describe the court, I describe the case number. So what am I doing? First I am describing court, then I am describing the case number, then I am describing the jurisdiction type, okay, whether it is your original or appellate, okay. Then I will also describe the case number, jurisdiction type, then what else is there? Section, very, very important, okay. You will also have to give the section number. Sir, what if I don't remember section number? Nothing, your competitor will remember the section number. Then you will have lot of time to remember section numbers. Whatever I am telling you, these section numbers you have to remember. There is no escape. You are sitting in CS professional. Okay, all the sections of your module you have to know. If not, at least which I am telling you, that you need to know. Okay, and especially the scanners, past exam questions. And then the sections number has to be written. After this is the first part, introduction. Then comes you introduce the parties. Introduced parties. When you introduce the parties, one will be plaintiff, defendant, appellant, respondent, etc. Then comes to the third one, is starting about the case. Okay, the start. Now how do you start the case? So, may it please the Honorable Chief Justice and his companions. So this is a language that the draftsman or the corrector is looking for. May it please the Honorable Chief Justice of the High Court and his Lordship companion. This is a mandatory thing that is to be written. So if you are learning it for the first time, you can start copying with me. Okay. May it please the Honorable Chief Justice and his Lordship companions, the petitioner most respectfully showeth. This is the language of the drafting that has to be given. The petitioner most respectfully showeth. And after that you will mention the facts of the case as it is given. Facts of the case is given in the facts, right? You just have to copy paste it. That's it. Whatever scenario is there. If it is a case of operation mismanagement, if it is a case of anything, you will explain it here. That's it. That's factual. That you have to copy paste. I'm teaching you the draft format where anything can be fit inside. Then, after you mention the facts, which will be depending on the case to case basis, then how do you end it, sir? Then you have to say few more things. That obviously court fees will be there, so you have to mention that the court fee has been attached and fixed. So the valuation of the suit is fixed at rupees so and so, and the requisite court fee has been appended here too. What will you write? That the requisite court fee has been appended here too. So then you mention about the court fees. Very simple, that whatever money is required to you, I have given it. Then you will say that this application has been filed within the period of limitation. Sir, all this is not given in module. I am telling you, you have to have a superior draft. Can you see all these code formats only I am dealing with? All these code formats only I am dealing. See this. In the High Court, you wanted to know what they write? In the High Court of Judicature at Bombay. So these are proper code formats. You write, you will get more than others, right? And these are all you can make out only that these are not some module little draft that is there. These are proper code drafts that we as lawyers and company secretaries we make. See, okay, all this is there. You see all these draft formats. So you need to have. Now this is a power of attorney, etc. All I'm going to show you. See here also how the section number has been. Now this is of CRPC, which has now been repeated, but you see the section numbers etc. has to be repeated. And may it please your honor. I've taught you how to write. Learn that one line and you can write it anywhere. Here, so court fees, limitation period, and then you will write the annexures. What you will write? The annexures. That the plaintiff will rely on the document list given under the annexures, and craves a leave to refer to and rely upon other documents in support of its claim. And we crave, we beg to take permission, leave to refer to other documents to support my claim. So, sir, when you write this, this is obviously not mandatory to be written, but it gives a very premium effect. Then, so what did we do after we wrote all this? After we start with may it please. Okay, it started with may it please. Then you wrote the facts of the case. Then, while ending, you gave all this. And now you will write something called as a prayer. What is the fourth and the last part? Is called as the prayer. Prayer clause, right? Prayer or the relief, whatever you can want, you can call it. Now, sir, how do we start? You see how I've written exactly, you have to write like that. Prayer or relief, okay? And then you write in the light of the aforesaid circumstances. See the language. In the light of the aforesaid circumstances, the plaintiff petitioner humbly prays that the court may be pleased to. That the court may be pleased to all the reliefs that you want. And in what common reliefs you can write? That injunction be given, that compensation be given, that interest be provided, whatever you want, you can write. Now I have written all the possible situations that you can ask for from your whatever fits into your case, copy paste it, done. The cost of the suit be given. Okay, the cost of the suit, because I filed a case, I have to pay the lawyers, I paid the stamp duty and now won the case, so I'll ask for all those things back to me. Okay, so but how do you start it? In the light of the facts and the circumstances above mentioned, above all these we mentioned, the petitioner humbly prays the below, that the defendant, that the other guy should be ordered to pay the plaintiff compensation of so and so along with interest so and so. Then pending the final hearing, he should be ordered to do the following things. Okay, a court receiver to be appointed. Now these are all factual aspects that you will write, and then still it is not ended. This line is very, very important. The etc. line. In practical life also, and in in your law, if a relief is not claimed, it cannot be asked in the court. If you've not written any relief in the petition, you are not allowed to ask. So just to be on the safer side, what do we write? Other reliefs also, as the court may deem fit. So you keep your sky's the limit. So you write everything, but in case if you forgot, still you'll write that such other relief as you feel fit. You can give me extra also, to be granted in favor of the plaintiff without any application. And then this normally person would end the end the entire thing. No. Further, you have to get, for this act of kindness, the petitioner is duty bound and shall ever pray. This I have seen almost in all the court drafts that are being filed. Almost all the court drafts, when they mention the relief, they ask for it. Let's see a detailed one. These are short. Okay. So this line you need to write, for this act of kindness, the petitioner is duty bound and shall ever pray. So what does it mean? It's just a high level English to mean that you're putting butter on the judge. Lordship and all these are not commonly, we don't really believe, but these are legal jargons that you have to throw to make it look legal. For this act of kindness, the petitioner is duty bound and shall ever pray. Have to write it, have to. Then this comes at the end of the prayer clause. This is the start of the prayer clause. Clear? Then you will write the affidavit. Sir, still draft is not over. Then you have to write in every single petition, there will be an affidavit that all the statements and facts have been read by me and is true to the best of my knowledge. So a verification or affidavit is given. Okay, whatever facts residing at so and so place, do hereby solemnly affirm. So I solemnly promise and state wherever that it is true to the best of my knowledge and no facts have been concealed by me. In affidavit, normally, since we are shortening the affidavit, in this we have to write two things. Can anyone tell me what two things you have to write in an affidavit? What two aspects you need to cover in an affidavit? Okay, very good. So the very first thing that you will cover in an affidavit, that everything is true to the best of my knowledge. But students just end there. There is a second point also. And can you see this and? No concealment. There is no facts have been. So no facts have been concealed by me. That also has to be mentioned. Right? And solemnly affirm on this date. The date will be given. Date. Okay. Then identified by me, the plaintiff is the deponent, because whenever writing an affidavit, so it is going to be in first person. First person means I solemnly affirm, I promise that so and so. You are the plaintiff. Okay. And the plaintiff will sign the affidavit. For example, the plaintiff will sign and he will be called as the deponent. Deponent is a person who gives the affidavit. Identified by me is the lawyer through the counsel details. Okay. So the counsel details will come and the draft is over. Done. So here we have completed the entire format for plaint. I have taught you, you can download it from the online, my website, free resources, learn it and write it. Your draft should be beautifully worded, which I have given you the practical draft. It is much more superior and contains everything mentioned in the module also. It covers extra because you have to give that extra effect to stand out in front of others. Right? Is this clear till here? If you understood, hit the like button, comment some good things which I feel more motivated to help you more. Now, sir, I finished the first part about court format. Is the first level complaint. Complaint is being made, everything is sorted. Now the second thing, judgment came against you. Now you have to go in appeal. In appeal, it is exactly copy paste format of plaint. But one extra thing is there. In appeal, there is only one new thing. I want you all to put in the comment section what is that one new thing which is there in plaint but is not there in appeal. I am reading the comment section. I will not move ahead. You all have to use your fingers and type. Okay. My objective is to help you and your objective is to help yourself. Okay. Sir, if in NCLT, what do we write instead of CJ, Chief Justice? So, on very good. I'll take you through a NCLT format also. Okay. Right. Okay. Now, bench, to the honorable bench and his companions. Very good. Very good. Sudalyandi, excellent. She has given the perfect answer. What is the extra thing that will be there, which is the grounds of, it will be the grounds of appeal. Excellent point. Now I will show you how grounds of appeal is to be written. Okay, how grounds of appeal is to be written. Okay, coming back. Chalo. Here everything is same, everything is going to be repeated. Okay, in the High Court of Judicature at Mumbai, your application number, here you will mention appellate jurisdiction. Okay, wherever you are there in the section, whichever section you are going in appeal, even if it is a special leave petition, you will say it is a special leave petition under section 136 of CPC. So those things will be mentioned. Then you will write plaintiff defendant, same as above. Okay, plaintiff defendant. Then you will write again same thing. May it please the honorable justice, you can write. If it is not Chief Justice, you can write the word honorable justice of the High Court or of NCLT and his lordship companions. You mentioned that petitioner is given. Now coming to the new things. Now this, what did I tell you? The petitioner most respectfully show with, you will give the facts of case. Right? Now see the new thing. Now this is also new. Okay, apart from ground of appeal, how do you come to the ground of appeal? Okay, in appeal obviously you'll have to, so if you see, now pay attention to my logic. When I'm going in appeal, there are already a history of I being into a court. So I will say initially that a petition was filed for XYZ and it was presented before the low subordinate court. Okay, and subordinate court has passed a judgment copy. Okay, has passed an order. Now you will come and write that aggrieved. Okay, aggrieved by the aforesaid judgment. Okay, decree of the court. This appeal is hereby filed on the following grounds. In case of appeal including special leave petition, you will mention that aggrieved, I am aggrieved by the decree or order of the court. Subordinate court did not understand. So I am aggrieved by the judgment decree of the lower court. This appeal is hereby filed on the following grounds, and then you mention the grounds of appeal. That is it. Your concept is done. And this ground of appeal, you can directly copy paste. Okay. Or you can just fit whatever things is fitting according to the facts. So I've made it almost all the points of module, practical life, I've covered all this. Now grounds of appeal, what it could be? Opportunity of being heard was not given, judgment was given without appreciation. Now see, the language in which I have written is so superior that when you write, not a single person in the entire classroom or entire this will write this level. See, the judgment and the decree are under appeal, are erroneous. The judgment which is under appeal is erroneous both on facts and law. It's a horrible judgment. It's erroneous both on facts and law. The learned trial court, the learned subordinate court failed to properly appreciate the evidence and has fallen into error. Okay, and the preponderance of probability was in my favor of preponderance. Now these are all high level English. Write it. Let the examiner know, okay, that the probability of justice was in appellant's favor. That there I had sufficient evidence, okay, to rebut all the claims made by the defendant. The impugned order, see the language and the words, the horrible order was patently illegal. It was horrible, erroneous, and deserves to be set aside. This language I have given, there has been a substantial, you have to create a kind of hype for the appeal to be taken, that there has been a substantial miscarriage of justice. The order is arbitrary, contravenes the provisions of law, and the court has placed too much reliance on the witness whose credibility is doubtful. So, what are we saying? That there is too much of the learned trial court, lower court, has given lot of importance to a witness who is really not a credible person in society. All those things, and rest all points are the same. That the court fee should be paid, limitation period, and annexures have been given on which we will rely. Finish. Prayer, same thing. After the prayer, you will write, for this act of kindness, the petitioner will always, be your slave. No, petitioner is duty bound and shall ever pray for your long and healthy life. This line exactly you copy paste at the end of the prayer. Okay, and then verification you will write. In verification, I told you three things: date, that everything is true, and there is no be any facts concealed. So 3 pointers to be written. And then obviously the fourth one also you can say that plaintiff, deponent, don't forget to write this word, and through the name of the counsel. Okay. So with this we finish plaint, and we finished the plaint and appeal. Now this is like a real court format which is there. You don't need to know the real court formats, how it is. I'm just showing you that now this is like in the real court. Okay, the court of city civil at exact location is given at Mumbai. Summary suit number. Now this is a summary suit. What do you have to do? What kind of a suit it is? The format will remain the same. The suit number, the entire under which section it is falling, plaintiff versus defendant. The plaintiff above mentioned most respectfully states as under. If you don't write that line, may and please, I believe you should write it. Okay. And I think one of you all were asking, what if I don't want to write, or what if it is NCLT? Then directly start with this line. Like they was asking, what if I don't want to write that? Then in front of NCLT, don't want it, Chief Justice. Then directly start the plaintiff most respectfully states and submits as under, and give the facts. Now these are all the facts. Now this will all differ from case to case basis. Then you'll write the plaintiff praise as below. So I've given you the best things. Then don't forget to write any other relief that the court feels they can give me. That also I'm ready to take all kind of things. Now till here I have completed plaint. Okay, if I have completed plaint, I have completed appeals. Okay, now I'm going into miscellaneous. Sir, what is miscellaneous? Miscellaneous are those other things that come in court that also come in the exam. Clear till here? Yes or no? Okay, clear till here? Yes or no? Now let's see. Now we are going to see miscellaneous application. Now we are going to see miscellaneous. The most important miscellaneous application repeatedly asked Why am I saying repeated? That many times it has been repeated. I have always told the students, learn a beautiful format for bail application and go. It always comes in the exam. Okay, and also how they can make it a little high, etc. I will tell you everything. Okay, now I will be teaching you bail application. Now in bail, what is happening? You have to introduce the court, then you have to tell in which case number, and then you have to say that you are making a request. Now that language of what do you have to say is all I am going to give you, which you have to learn and directly write. So first you have to tell, obviously this is not going to be a civil matter, it has to be a criminal matter. So the case number will also be CR number, criminal record number, right, or criminal complaint number. So you can write CC number, that is criminal complaint number, or CR number, criminal record number, anything you can write, because the application will have something, application number so and so, date of the court you will write. Now obviously criminal courts will be metropolitan court, okay, your high court, all those things as given in the court. Then obviously the introduction of the party is complainant and the other one is the accused. Till now, all the drafts that we did and all the drafts in your module mostly are about plaintiff defendant, and in the exam they'll ask criminal draft. Again, understand, they are teaching you civil and exam they give you criminal, you know that, because they know what you don't know and they will ask you that. How many criminal drafts are there in your module? Hardly any. And in exam they are asking criminal drafts only. So you in criminal, one becomes complainant and the other one becomes accused, always. Clear? Now you start, may it please your honor. Now we are writing a bail application. Okay, now bail application is being given. May it please your honor, okay, on behalf of the accused, named, accused, whoever is being named above, it most respectfully submitted, applied and prayed as under. See the language and the this, and always start so beautifully that it sounds legal and you know that this guy is a topper. On behalf of the accused. Now obviously the accused himself will not do, he'll do it to an advocate. So on behalf of the accused, it is most respectfully submitted, applied and prayed. Write it. You see the draft in your module and you see this draft. This is the real life draft. I have made a bail application in court also. Okay, so I'll be telling you what all it is there. So write this. This is a real life practical draft format. So you can use it in your real life also. Now, again, now we are trying to get someone in bail. So what all will you say? If you want to get a person bail, what all will you tell? Okay, what all will you tell? Yes. So Dev has asked, sir, plaint format will be same in civil and criminal. Yes, but the words will change. That in complaint and plaint format is same. Only instead of plaintiff, you'll write the word complainant and accused. Very good question. Nice. Okay. Now, one more question. Do we need to write every grounds of appeal or a single ground for drafting, sir? Please, single draft of you will write for grounds of appeal. If your ground of appeal, only one point you mention and one point is denied by court, so you lost the case there only. At least mention 5. At least mention 5 grounds, that at least if one point doesn't work, I'll tell that other point is there. If that doesn't work, third point. You can't write 1. 1 you will get 0 in exam, okay? So that you cannot do. Grounds of appeal has to be minimum 5. Okay, now coming to the further thing, on behalf of the accused, we most respectfully share. Now what do we tell now? One simple line, this is there in every bail application. When you go to a criminal lawyer, what do they tell? That what you have to tell? Do you agree to the crime or you don't agree? Don't agree. You have to say that the police has falsely implicated the applicant. that they have falsely implicated me in this case, falsely, fixed me into this case, falsely dragged me into this case, falsely implicated me into the case. That the applicant prefers to file the bail application. Okay, he was taken in custody, and then a little bit of line you can write that I was taken to XYZ police station under this criminal record number, and then I was taken into judicial custody. The police have falsely implicated me and arrested me without any reason. Then I can, if the person is not a habitual offender, I will say that he is an innocent person, not committed any crimes in the past. Okay, you will say that he is a permanent resident of India. Why will he run out of India? He is a permanent resident of India. The applicant is neither required for any investigation, non-custodial interrogation. Like, why are you dragging him? He is not required for any kind of investigation or interrogation. He is not required only. Why are you doing? He has very good antecedents. Antecedents means background. So when you write this kind of language, it will feel good. Your module draft is a baby draft, okay, which is not used in today's courts. The applicant undertakes to cooperate with the police. No useful service will be served if he is kept in jail custody, as no recovery has been made from him. He will not flee from the court of justice. He will not tamper with the evidence of witness, and he will comply with all the conditions of this. And therefore, it is prayed that the applicant may be released on bail. So now, after giving your application, may it please your honor, you see this kind of bail application students are writing. Then you can demand marks from the ICSI, because these are real court drafts. Okay, and therefore it is prayed. Now you are writing the prayer. Okay, that we be released on bail. Any kind of cash or security bond is allowed. Cash means we will give a cash, or security means some kind of person is giving your security. Be released on bail, furnishing surety, and any other relief as the court deems fit. Now this line you can always write: for this act of kindness, the accused shall be duty bound and ever pray. Clear till here? So this is a very commonly asked question. So in order to make it complicated, which they cannot, they will just say make a surety bail application, make a security bail. What? Nothing. You just have to say everything same, that we are ready to furnish the security, we are furnished to produce the cash bond. That's all you will write in the prayer. The grounds will remain the same. Okay. Now let's take off other things. Okay. Yes. Okay. So that is it. These are the most important and common draft formats which are there in court. You open your module, all the drafts which have come in respect of court will be fitted, or will be fitting into this what I have made only. Clear till here? Yes or no? Is this clear? Yes or no? So then I can begin with the second part, which I will complete in the next 45 to 1 hour period. Clear? I want everyone in the chat box to write clear in the chat box. So what is the difference? Very good. What is the difference between bail and bail bond? Excellent. Answer: the plaint format will be the same as civil and criminal. Answer is yes. Plaint format will be the format is the same. Only criminal application number, those you will have to mention. Now bail and bail bond is same. Bail is a bond only. See, bail. So bail and bail bond is same. See, bail is a concept. Bail is a concept. And when you are getting bail, you have to give a undertaking. That undertaking is what we are making, which is called as a bail bond. So we are literally making a bail bond only. Clear till here? So bail is a concept of releasing a person from police custody to private custody. That is the meaning of bail. Bail bond is when we are releasing it, the court will ask you that please produce a surety, that in case if you don't come, that surety we will arrest. Or you give a FD as a bond, right? A bond is a financial undertaking. So we will tell you that you give me for 10 lakh rupees bond. Okay, give it here to the court. Salman Khan, when he was there, he was released on bail bond. He had to deposit a kind of a cash deposit or a FD or some kind of amount. That if you don't appear, we will, debit that bond. Concept clear? Clear till here? Yes or no? The second part is what we are going to do now. The second part is about agreements and deeds. Now, we'll just take a 2 minute break, 2 minutes break, okay? And till that, I want you to at least go through the formats, and then we will start and complete this entire chapter, okay? And this draft which I'm going to do now after the break, that is a 2 minute break only, breather we'll just take to before we restart. After that, this is the most commonly, and I can give you in writing I can give you. This video is there, you can always check it, it will be there on YouTube only. 110% one question will be framed from what we are doing today. 110% from this part, second part, a question has to come in your examination with respect to agreements or deeds. Common sense, your entire module is filled with this. Question will come from your only mortgage deed, partnership deed, any sale deed, lease deed. From there only it comes, right? You could say foreign exchange agreements, etc. Okay, merger agreements, etc. So now we will be starting this after. So it's a very important topic. Take a breather, and we will be starting with all the key important points as well. Clear? So 2 minutes we resume. Till that, I'm giving you 2 minutes to write your doubts and to like this video and to share it with your friends as well. I request you to share this video. That is the least that you can do. Share it with your friends, like the video, and wherever possible, let people know about us and that the work that we are doing. Okay? I'll be back, have a water break, and I will return. Same for you. You open your module till now and see all the code formats. And when I completed it, you can write in the comment section. So I'll feel happy to read. Hi guys, am I audible and visible? Quickly tell me so I can complete the other part. Okay, now before I start, I think there is a question, okay, of Khushi. So what Khushi is saying that, sir, which are the important drafts according to me, and as there are many drafts to remember. Now listen, I tell this to all my students, okay, and this answer also I will be giving you all. But till then, those who have not liked the video, please like the video. It's very, very important. Okay, it should boost my confidence. I should feel happy that I'm able to, cater to you all. So that's very, very important. Okay. Okay. So obviously, see, listen, I've been teaching drafting for 10, 12 years. Okay. I've got very good marks in drafting when I was a student. Even in college, I had one drafting competition. So let me tell you which draft is important. Ready? Yes or no? Everyone, yes or no in the chat box. I will be telling you, okay? Chalo. Let's begin. Let's begin. Yep. Chalo. Okay. Hi. So we'll be starting with the second part of drafting. Now, this part is about agreements and deeds, which is a sure shot exam question. It has been coming in every single attempt from the past 10 years, and in your attempt as well, a question will definitely be framed from agreements and deeds, which we'll be doing in this part. Before I start, a student has asked me to, which are the important draft agreements or deeds so they can prepare. The answer is very simple that this drafting subject, the purpose of this subject is to teach you to draft anything under the sun. If anything under the sun you cannot draft, that means you have not understood the concept of drafting, and it becomes very big risk of not getting good marks in your exams. In reverse, if you get confidence that now I have understood the format, then any question that comes, the format will not change. The format for agreements and deeds will be exactly the same. The contents within the detailed part you will write according to the draft. So understand this thing that drafting, once you understand the drafts, the skeleton, the legal requirements, you are good to go, right? And in exams, you have to make your own single draft format, which I have already prepared to you, which is highly worded, which gives you maximum marks, and just the factual aspects will have to be changed as per the case to case. Let's begin. Clear? So there are no important drafts. You need to know all the drafts, or I should say a draft format where you can fit any kind of thing inside, which I'm going to teach you. So first thing is, whenever you come, any draft or deed is agreement. For example, in June 2025, they said draft a mortgage deed. So, or before that they had asked lease agreement. Before that they had asked about power of attorney, right? Concept will remain the same. Now pay attention to this. So after this session, you will be able to draft anything under the sun, my guarantee. So agreement. So here this is called as the title. What it is called? Title. What is the agreement about? Okay, is it a NOC? Is it an indemnity bond? Is it a partnership deed? Is it a foreign collaboration agreement? It is a merger agreement. It is sale deed, lease deed, leave and license agreement. First, whatever it is, you have to write the title here. Concept clear? So example, sale deed. So you sold a house, this will be the sale deed. Then you will write this sale deed, this agreement deed, this mortgage deed, this whatever of this deed of assignment, deed of etc. So if a IPR is there, I assign it, I give it to someone else to use, like renting, right? Renting your intellectual property. So this deed of whatever it is, assignment, sale, partnership, you'll mention that. So what will you write here? The title is made and entered into at Mumbai. That you should write, in the exam they keep it blank only, they write the word dash and then they will write a place, that means you have to write the place here. On, that means you have to write the date here. So this is done. Then between, see the way I have written, that's exactly how you will write, because this is the best practice to be followed. Between party 1 and party 2. But see the way the party 1 details are prescribed. Okay, that Mr. A, resident of so and so, hereinafter called as the first party. Now you can also write hereinafter called as the seller, hereinafter called as the assigner, here as called as the inventor, here is called as a licensor, that way, right? So either you write, if you don't know anything, write the first party. But if you know one is a seller, one is a buyer, write the first party seller. No? If you know he's a mortgager, write the word mortgager. If you know he's a lessor, write the word lessor. Okay, so whatever it is, you will write. Now, whenever you write this word, first party, does that mean that that guy only has to come? Answer is no. The expression first party, unless repugnant to the context, unless a contrary meaning appears, it means that even he can come. It also, his legal heirs can come, his executors, administrators, assign can also come. That's it. So hereinafter called as the first party of the first part. So this is sounds little jargon, legal jargon, but this is the way to present. And anything comes here. Any kind of agreement will come here, right? And the second thing. Okay. And the second thing is the second party. Now, how do you mention the second party? Exactly the same. If it is a company having a registered office at so and so place, hereinafter, like we are not writing the second party. What did I write? I wrote here licensee, and the language is same. Unless repugnant to the context, it's a language. It shall include legal heirs, permitted assigns, anyone, etc., of the second part or of the other part. So many times students fail to write all these keywords, because of which for no reason they are losing marks. Right? Now, coming to the other part. Now, once you finish this, what have you done? You've given the introduction to the parties. You've introduced the parties, party 1 and party 2. Hereinafter called as the first party and the second party. Now, what are we starting? Pay attention. Now, if you see directly of the other part, you finish party 1, party 2 introduction. Now, always by default, you will write the word whereas, whereas, and whereas, and whereas, and whereas. Clear till here? I want you all to put in the chat section, in the comment section, what does this whereas mean? What does this whereas? What is the legal word of the whereas? Nobody talks like this, but this is the drafting format. Whereas I'll show you every single agreement, this is code formats. I'll show you every single agreement. Okay, now this is a Bandra. Every seal deed, okay, every agreement this is a seal deed, right? Now see, this is a real life case, okay? And whereas, can you see this? Hereinafter called as purchaser, unless repugnant. Now this is a real life draft that we've made, okay? Real life which we use in courts. hereinafter called as of the other part, and whereas the second party. Okay. Now then you write whereas you can see, and whereas, and then once you finish that, then you start with this. Now these deed witnesses as follows. So my question to you is, what is the word whereas called? Quickly, everyone. Recitals. Excellent. Okay. So this is called as recitals. What it is called? Recital. Now a recital is a short summary. Is a short summary of the entire draft. But what people don't know, there is offer and acceptance given in all recitals. Offer and acceptance. These students don't know because in the module they have not told you. So obviously, if you're just referring to module, this you will never know. A recital will always contain an offer and acceptance. See, they will say, first they introduce that whereas party 1 is doing this business, party 2 is doing this business. Then they mention whereas party 1 has approached party 2 to do whatever, and they have mutually agreed. So when they have approached means what? They have told it is an offer, and mutually agreed means acceptance. So party 1 has approached party 2 to sell the house, and the parties have agreed mutually on the terms and conditions mentioned below. Clear till here? When you read the theory part of your drafting chapter where recitals are given, they tell you there are two kinds of recitals. Can anyone tell me in the chat box which are the two kinds of recitals that are there? Open your drafting module and go and see narrative recitals and introductory recitals. They will tell you that recitals are of two kinds. Okay. So coming back to the important part, in recital you will give the whereas and all in caps. Then you start with the other part. Now this deed witnesses as follows. What it is called? Agreement witnesses as follows. That is called as testatum. A testatum contains the detailed terms and conditions. About now, recital was only summary. This is detailed terms and conditions will be given. Now therefore the agreement witnesses as follows, and then you will give the clause, each clause in depth. Now I have made all these clauses in depth for you all as per the highest possible wording. So all this, whether covenant clause, indemnity clause, force majeure clause, okay, termination clause, confidentiality clause, restrictive clause, all these you have to learn. Non-compete clause, directly copy paste, okay, into the examination. So these are the important clauses which you can fit into the exam. Okay, see you're also seeing the sale agreement, right? Sale deed. So see, now the deed witnesses, then they will write all the detailed clauses, and then they will end it. Seller and buyer. Concept clear? Now let's go into the detailed terms and conditions and let's see how it is. So in that case, when you have to draft, a particular scenario will always be presented to you. A particular scenario will be given, then you have to think from that scenario point of view. By law, there is a very famous rule in law. Tell me whether you know it or no. Rule in law that no consideration, no agreement, no contract, no consideration, no contract. There are exceptions like gift, etc. But in the general rule is that no consideration, no contract. Yes or no? Yes, sir. You're right. Now, every single agreement, open your module, every single agreement mandatorily contains a consideration clause. Mandatorily contains a consideration clause. And that too the very first one. So as a student, when I am thinking that I have to start any agreement with the consideration clause, Why not learn it perfectly with actually how practically it is taught or practically it is done? So see this line. This is from a practical draft. I have copy pasted all this. In consideration, now obviously consideration is there. In consideration of amount which has been paid by party A to party B on so and so date, the receipt of which is acknowledged herein. So write this line that the receipt of that amount is acknowledged herein and the copy of it has been attached. So in consideration of the money, the party B has transferred, assigned and delivered whatever, the house, the goods, whatever, to party B as per the terms and conditions of the agreement. Now consideration clause can be in your own words, but these points you can write. What all points? You mention the amount, but you also amount that the receipt of that has been acknowledged. And on basis of that, what are you doing in the agreement? Right? And you know that this is the start. This is the start of all agreements. So might as well start beautifully. Right? Then we go second. Now in any agreement, any kind of agreement, sale agreement, technology transfer agreement, intellectual property agreement, etc. So there will always be some kind of promises, and if those promises will be breached, then some kind of indemnity will be given. That if I breach this particular clause, then what will happen? Then what kind of protection is given? So covenant are the promises, and if you breach those, any party breaches the promise, then how will they pay for the losses? Now it's very simple to understand, okay? And normally, if I practically talk about multiple indemnities and is given, it's a very important clause is there, okay? And it's heavily negotiated in the agreement. Sir, what does it mean? For example, I'm a seller company and I'm selling it to a buyer company. Okay? Seller and buyer. Let's talk about, give me a practical example of any kind of recent sale of purchase of any company. Purchase of any company, you all can tell me. One company has purchased another company. Yes, so Dev has again further asked, in exam, do we have to specifically write the clause title or directly start with the clause? Again, it is a very good practice to start with the title. Mention the title like how I have mentioned. In practical draft, if I show you practical draft deeds, you will get shocked. All the clauses have been given with headings. These. Let me see if I can pull that for you. Currently I don't have that, you know. So it's not mandatorily required to write the clause title, but if you see any practical corporate draft, see a share purchase agreement, they give all these kind of headings. Because, and in the title, if you read a detailed kind of a clause of any particular firm or etc., they instead have the index. In the index, they will be telling that this clause. So it's easy to locate 1.1. Your 7th point is the indemnity clause, and in 7.1, 7.2, 7.3, details about indemnity clause will be there. 8th point could be a exit clause. Okay. So all those things can be there. Seller and buyer company. So when the seller company is selling their company, the buyer company is scared that what if I buy and then there is a tax, uh, you know, tax notice that we received for the time past events. So you please give us an indemnity that if there is any, notices received by the income tax department for the period of this 2 days, then you will be held responsible and buyer company will not pay. So these are indemnity clauses that one party will first promise, then the second party will tell, don't worry guys, I will pay for it. right? So again, so writing of these headings, like these headings, is recommended, not mandatory. Okay, so I always prefer, and in real life, always clauses, headings are given. It's easy to locate, right? Even internally, also they have further clauses, etc. Okay, so further, let's read about covenant. So, covenant could be a promise. Party A hereby covenants to party B the following assurances: that the goods are clear title, that the property is clear title, that it is free from all encumbrances, there is no legal dispute, okay, that we have fully complied. Now if I am buying a company of another country, so I will tell them to give me that a covenant, all the legal all the, there is no legal dispute, they are fully complied with the applicable laws and regulations, and all the transfers are having clear title. Then you will say indemnity. How do you start off? Connected with the covenant. Covenant is a promise. Earlier you gave me promises that everything was clear title. In event any of the covenant, see the language that they've given. Okay, this language you have to present in the exam. If any of the covenants, representation or warranties are found to be false, inaccurate or misleading, if any of the promises, representation, warranties are found to be false, inaccurate or misleading, and the party suffers any financial loss, then this party shall be solely responsible for all the liabilities, claims, etc. Force majeure clause is also there. Earlier, pre-COVID, this was always taken like a joke and formality. In COVID, what happened? All the contracts that did not have force majeure clause went into litigation. Anyone, because force majeure means act of God. Means act of God. Ideally, they don't mean act of God, they mean any act which happens which is beyond the control of the parties, like COVID-19. If imagine during the time of pre-COVID, I had taken money from you to deliver goods to you, and suddenly lockdown was hit, movement is not allowed, that nobody of earlier had thought, and all the contracts were breached. Only the contracts which had force majeure clause were saved. Why? Because neither of the parties, this means force majeure means that neither of the parties shall be responsible for any failure or delay. Okay, if any um, if any force majeure event has occurred, or if any event which is beyond the control of the parties, right? And these events may be and may include but not limited to. So these are most commonly written, and in this now you will see natural disasters, war, terrorism, government restrictions, cyber, and nowadays people are also writing pandemics. Pandemics, etc., epidemic, etc. If any force majeure events continues to prevent the performance, then the party shall have a right to terminate the agreement, and the party will not be held responsible. So COVID, this force majeure agreements was earlier taken like a joke. Nowadays everybody is writing that, you never know what kind of thing happens. You have a war or a next pandemic when it will hit, etc. Then comes as confidentiality clause, especially for technology transfer agreements, especially for intellectual property rights, where certain rights are being, there is assignment of trademark, copyright, patents, okay, design, etc. Then confidentiality clause will come. And how do you start the confidentiality clause? That both the parties agree that this contract has confidential information, and all the information exchange, documents, correspondence exchange are strictly confidential, and no party shall disclose the contents or to a third party without obtaining consent of the prior party. Okay, then you will also say that what if I want to give it to my employee to draft it? So there it is allowed. So for this purpose, confidential information includes but not limited to business strat. So it includes, but it is not limited to all these things. Confidential is there, okay? Then comes, now you see these clauses which I have made is at a higher level, okay? Because this I have all these clauses and etc. are from real life practical drafts. So therefore this become very important. On our website you can go and download all these documents. It is for you to go and get exemption in exam. Termination, so you don't end up writing basic little wordings of module. Okay, obviously module is there, but everybody is writing that. You need to write something more and more premium and a little more legal. This agreement may be terminated by either of the parties on the following cases: the termination clause, how you can end, and arbitration clause. Now, how every single agreement, contract, commercial agreements are having arbitration clause today. Okay, now how do you draft an arbitration clause? How do you write? Now you cannot write in your own words and expect marks. Exactly learn this, copy paste it in your exam. You see, you will get exemption. If the parties fail to resolve a dispute amicably, then such a matter shall be settled through arbitration. The arbitration shall be conducted as per the Arbitration Act 1996. The location of this will be there. The language will be so and so. Each party shall appoint an arbitrator, and both the arbitrators shall appoint a third arbitrator. Parties agree that the decision of the arbitrator shall binding on both the parties, and the cost of arbitration shall be bear by both the parties. Sir, in my examination, I never wrote all this. Obviously, restriction. So again, restrictive covenant. Now, sir, what is a restrictive covenant? For example, if I am a company, I am appointing an agent. I can give him a restrictive covenant. Don't sell above this price. Don't sell below this price. Don't sell beyond this area. Okay, a restrictive covenant could be have a geographical limitations, etc. Non-compete clause. This is for your employees. Today, if you go to see the world, you hire an employee, he learns from you, and he starts competing business. So nowadays, and I have seen so many matters also where companies have spent immensely on an employee, sent them abroad to learn, and that guy leaves and joins a competitor. So obviously you need to draft a non-compete clause. So there is in Contract Act a agreement in restraint of trade is void, means can I have a non-compete clause? Answer is absolutely yes, but you have to be very reasonable that you cannot compete, cannot solicit my clients. You cannot, start a competing business within this vicinity. A blanket non-compete clause is void ab initio, right? So I have written how practically it has been made. That all you can get it from the website. And then after mentioning all of this beautifully, as I have explained it to you, then comes something called as the testimonium. What it comes? Testimonium. Sir, what is a testimonium? A testimonium is it starts with the word in witness whereof. A testimonium is, you can write it, testimonium. Okay, testimonium is called as the closure of the draft, closing part of draft. It always states that the in witness whereof, it starts with the word in witness whereof the parties have set their hands. When I say set their hand, means they've signed on the dates mentioned herein. Then always remember that whenever it is a deed, go to the definition of deed in your module. Signed, sealed, delivered. Yes, but in the agreement you are not writing signed, sealed, delivered. So always whenever it is a deed, please mention this line: signed, sealed, delivered, because it makes the agreement, the deed requirement is a deed is a instrument which needs to be signed, sealed, delivered. So it needs to be signed, has a seal of a notary, delivered to both the parties. Name of party in presence of witness, sign. Now you can see all this is how practically it is there. Okay, photo of this, name of first party, and they sign here. Okay, then so we are done with the first and the most key things, or everything else will rotate around the same thing only. Okay. Now coming to the some miscellaneous formats. Miscellaneous format also that come. So as I told you, in your exam you have agreements, deeds, and some miscellaneous things also. For this miscellaneous, there is special requirements. These special requirements you need to know. If you don't know the special requirement, you get 0 in the exam, direct 0. Legal formalities only not complete. Understood? I will show you how it is. First we come to will. Okay, will. Now we are going to see the format for a will. So very simple, a will can be made in first person because there is no second party. I, son of so and so, hereby declare that I have not made any will, or I revoke all my earlier wills. This is very important because what if he made one more will, later he made another will, then it will create a conflict. So either you say I have not made any of my earlier wills, or you say I hereby revoke my earlier wills and do hereby declare that this is my last will and testament. So in miscellaneous, like a power of attorney, there is no second party, not an agreement, a promissory note. So those also come. Will, single party you can draft. I declare that I am possessed and occupied of the immovable property. Now see the language. This is the language of law. I am possessed and occupied of the immovable property mentioned herein. And now I am 65 years old. I am physically and mentally fit and have full. Now very important. If this line is not written, your will, you will get 0. That you are physically and mentally fit and have absolute power, and you are making this will with no force. You will see in every will, if I take you through any will of practically, you will see this has to be given. We are code formats, that is was in other formats where I have my will. So all the wills that we have, the format, so that is different. I hereby declare, see, that I bequeath my property mentioned in schedule 1 to son A. All the properties mentioned in schedule B to my son C, to my all the mentioned in this schedule to this one. So that's how you bequeath your property. And then you say that I hereby declare that after my death the property will go on and devolve by this share, wife, daughter, son. I hereby declare that I am executing this last will voluntary out of my free will without any compulsion or pressure. If this is not given, 0 marks. Okay, or you could say even you might get marks, but it's very difficult to clear the paper when you don't know the essentials of a particular thing. Okay, then in a will you also mention who will be your executor of the will, right? And then I will declare that it has been read out, because see, in a will what happens that normally old people make the will. So it's very important to say that they are voluntarily doing it, not in force, and they are mentally and physically fit. In witness whereof they sign it and done. Concept clear? Yes or no? Seal deed we've already done. Then we'll come to another key draft, which is your power of attorney. Extremely, extremely, extremely important. Okay, now so many times someone asks that, sir, what is important? Obviously, what is important, I've kept it all in the draft format. All of this is there in this document. You will get it from my website. Okay, power of attorney. Every time they are asking. Now, power of attorney. What is a power of attorney? So, a power of attorney is a law of agency will apply. Okay, and a person, if he has the power, he also has a power to do something. He is authorizing someone else to do something on his behalf. So you appoint an attorney. So there will be a principal and there will be a agent. Principal. Can anyone tell me that the person who is making the power of attorney, what is he called and what is the agent called? The principal who is making the power of attorney, they are called as the principal, or they can also be called as test. Main is principal and agent is called as the attorney. Concept clear? So the format of it starting, okay, any kind of power of attorney, when you see, I don't know if I have it here, let's see, POA, these are leave and license agreement, indemnity bond. Yeah. Okay. Here. Now a power of attorney. See, this is a practical thing, okay? Practical draft which is there. That how it is starting? Know all men. It's a starting. So power of attorney could be of two kinds. Power of attorney is of two kinds. Can anyone tell me which it is? So one is a general power of attorney and the other one is a special power of attorney. So general applies to more than one act, more than one acts, and this applies to a specific. General power of attorney is given to whom? To maybe directors of the company, to maybe to the managers, and overall you handle all these day-to-day affairs. Special power of attorney could be to sell a house. A special power of attorney could also proxy form. Go in this meeting, vote and come. The special power of attorney. Or a special power of attorney to do one thing. Okay. So here we are seeing a general power of attorney. See the formats. General power of attorney. Now this is to open a bank account. It is to giving a general power of attorney to give a bank account to know all men. Now in this, what do you see now? I've changed the names. That I do hereby appoint and constitute XYZ as my attorney. As my attorney. Concept clear? So in power of attorney, I am looking as a character. I am looking for some things. That did this guy start with know all men? Presents that. This is the language. You have to write it. And he will be. Did he mention his principal and attorney? Did he do that? And did he mention that you are hereby ready to appoint someone as your attorney to do all the following acts? So whatever acts are there, that has to be done to do. Then you mention that to execute this, to sign this, to transfer this, to appear, etc. And then you will write this important line. The other thing, as a corrector or an examiner, I'm looking. Did this guy do this? What you will say, as I told you, that a power of attorney, law of agency applies. So you will tell that I hereby understand all the acts done by my agent in good faith shall be deemed to be my acts. So the principle hereby takes to ratify, also hereby takes to confirm, ratify whatever the attorney does in good faith shall be his acts. Okay. In witness whereof, and you sign and close it. Clear? Then comes as a promissory note. Promissory note is again one-sided. I promise to pay so and so or so much money. That is it. Okay, then you're done. This is the format of it. Has income, I receive cash in witness whereof. Not very important. Then comes as a special power of attorney. Okay. Now again, what I told you, what the corrector will be looking. Did you start like this? Did you write the parties correctly? Party 1, party 2, and did you say that I am hereby appointing him as my attorney, and did you mention that I hereby constitute and appoint so and so as my lawful attorney to do all the following acts. And then the last line will be in witness whereof you can write, and I hereby understand that all the here, or I hereby agree that all the acts, deeds, this done by in good faith shall I hereby ratify, confirm, and all the acts of the attorney shall be deemed to be my acts. This sentence we are looking for, right? Irrevocable power of attorney. Now, power of attorney further can be revocable. Now, POA could either be revocable or irrevocable. Now, my question to you with respect to your property, okay? Will you give to someone a revocable power of attorney or irrevocable? Revocable means you can cancel at any time. Irrevocable means you can never cancel it. Will you ever give to anyone revocable or irrevocable? Tell me. It's very, very important to understand the concept, and I am expecting you to reply. Okay. Quickly. Waiting for you all. Okay, quickly. A power of attorney is revocable or irrevocable. What would you do? Revocable. Varun is saying revocable. Excellent. Varun, very good. Now, my question is that, boss, if every one of you all will mention revocable, then when will the irrevocable power of attorney begin? It's an irrelevant concept, now. Nobody will ever give a irrevocable power of attorney to someone. So obviously, most of the cases, 99.99% cases, people will give revocable. But what will fall under irrevocable? Why will someone ever be so stupid to give a irrevocable power of attorney? And in the exam, they ask irrevocable power of attorney. You know that? You'll get a shock of your life. In exam, they ask irrevocable, which is so rare. Which scenario can that fall? Quickly tell message and tell me. In your module also it is there. It's not that I'm telling something random. It is there in the module also. Quickly, when an irrevocable power of attorney is given, should I tell you? You will give an irrevocable power of attorney in this scenario. So what happens is, pay attention. What happens is, pay attention. Okay. Now, when you go to take a home loan, the bank gives you the loan, takes a irrevocable power of attorney to sell house in case of default. Concept clear? See, when you go to take a home loan, the creditor says that if you default, we want to sell it, but you will try to block me from selling. You will say, no, don't sell. So they already make you execute an irrevocable power of attorney that you have defaulted or you will default, etc. Then we will directly go in the market and sell it. And in the exam and in the module, same scenario has been covered. Concept clear? There is no other case where irrevocable power of attorney will be more relevant. Understood? So pay attention. So to all by whom it is there, all this you have to leave blank only. Don't go and write proper factual, assuming facts, you will get 0. Okay. Whereas now you'll write irrevocable power of attorney. So if I just want to understand what is happening, there is a owner, whatever. But I have explained you the case. So you are giving an irrevocable power of attorney to a bank to sell in case when you default or a person defaults. Concept clear? Give deed again. Now this is among the last miscellaneous format, which is extremely important. Okay. Now, give deed again, it is one of the exceptions where even when consideration is not given, you are the contract is valid. But here you mentioned that the consideration is love and affection, that you will mention. But my question is, you mention a very heavily worded, legally worded give deed. But if this line you miss, you will get 0. Can anyone tell me what is that one line? One important thing which if you don't mention in give deed, you get a 0. Quickly, what it is, tell me. Everybody, very nice words they mention. See, this give deed made on so and so date between so and so person. One is a donor, the other one is donee. The expression shall, unless repugnant to the context, shall mean to refer all this of the first and second one. That all is done. But consideration is love and affection. This also you write, and then in the end you end it also, to have and to hold absolutely free from all encumbrances, in witness whereof, signed, sealed, delivered, everything has been done. Still, you will get 0. What is that one line? I want to see. I am not going to tell you. I want to read from you all. Think and tell me, in give deed, what is that one line? If you don't mention, the give deed is 0. In consideration of love and affection, I am saying that is there. I have done all of that. Still, a person can get 0. What is that? What is that one line? In witness whereof, signed, sealed, delivered, everything given. Okay, to have and to hold, free from all encumbrances, everything is done. Love and affection. Donor is the lawful owner. Donor, donee. Still, then what is that one thing? If you don't mention the give deed, you will get 0. Mention. Quickly type and tell me. Do you know? Yes or no? If you don't know, just write IDK. I don't know. If you don't know, mention IDK and leave it. Excellent. Krishna has answered it, that gift requires acceptance. Gift has to be accepted. Gift has to be accepted. If a gift in the give deed, if you fail to mention that it has been accepted, it is invalid, because I give a gift to Shah Rukh Khan, to whoever I want. I'll give it to Bill Gates. It's not valid. Gift has to be accepted. Here, see this line. The donee has accepted from the donor the gift of shares. If that is not mentioned, your gift is invalid. You know the legal law. Read it. You know better than me. Transfer of Property Act. Okay, so that has to be mentioned, and then your gift is valid. Okay, now just one thing is, one more last part is, if they ever ask you to write a writ petition, now this also they can ask you, it's a court format only, but in writ petition it's the same as a court format. You have to mention just article 226 or 32 wherever you're approaching. But one fact you have to mention for writ petition, okay, that is, he is a citizen of India. Citizen of India in writ petition, because if you are not a citizen of India and you then certain fundamental rights you cannot apply. Only fundamental rights, certain of them are only guaranteed to citizens of India, like Article 19(1)(g), freedom of business and profession. A fundamental right is given to citizens only. So if a writ petition come, make the plaint but mention the citizen of India. Clear? With this, I have completed all the possible drafts that is there. You go to your module also, any of the chapters, it will be completed. Just two more things I wanted to tell you all. One is a legal notice how to send and how to reply to legal notice, that also we'll see in the second part, maybe in the next lecture. And second is, we have always seen plaint. Now all this I'm telling you, they have not asked in the exam, but very good chance they will ask. So this, again, let me tell you one more thing. Okay, so this I will try to cover it in the tomorrow's lecture. So this is not asked yet, but important. Okay, formats of legal notice, how to draft, reply to legal notice, how to do. We have done always plaint, but we've never done a written statement. It has never come, but it is very important. How to draft written statement. Sir, what does it mean? You have sent a plaint to someone, court petition. Now when we reply, how to reply to a plaint, how to reply to a legal notice is considered to be a reply or a written statement. Have you understood this? What I'm telling you, that is also equally important. And one last one is a legal opinion. What it is? How to draft a legal opinion. For example, all this is not this, but can come in exam. So it has not come in the exam. Obviously, what has come, I have explained everything. But this, according to me, still you need to know to be perfect in drafting. Okay, legal notice, how to reply to legal notice. Plaint we have done, how to write, reply to plaint, and format for a legal opinion. So a client will come to you and tell that, whether GST will be applicable in my business or no, tell me. So it's a legal opinion. So all this we will do in tomorrow's lecture. With this, I conclude my entire marathon for today. If you found this beneficial, I want you to like the video. It doesn't cost you anything. It just motivates us to help you even more. I want you more I want from you to wait. You need to share this video with your study group. This is my request. If you learn from me, please help it to others. The more you help spread the word, that good will come back to you, and we also will feel very happy that we can cater to more number of students. Okay, so when you are sharing knowledge, you want that it is shared with as many number of people who need it. So that is my request. Wherever you see, please do comment about us and let us know that the work that we are doing. So with this, I wish you all the very best for your examinations. I have covered almost everything. Open the past exam question, any module topic, it will fit in the draft that I have done, and I have taught you drafts of the highest level. Doing that will only give you more marks more than module. So I wrap up today's marathon. Thank you so much for being so nice, so responsive, and sitting right from the start till the end. As a CS professional student, I know the timing is so important. Time is so important. You've given your valuable time to me. Thank you so much. So what will we cover tomorrow? Tomorrow I plan to take you all through a little bit of chapters, each chapter wise importance, taking you through an overview of chapters, all these drafts if you all are doing this. So today I have covered the drafts. Tomorrow I'll try to cover the theory part, okay, which is also important in the exam. So doing it from the module is good enough. Okay, if you know the theory, good. But the case laws, we'll have a bird's eye view over the theoretical chapters. Each chapter wise we'll try to figure. Okay, with this I conclude today's marathon. Thank you so much guys. Wish you all the very best, and I will see you all in the next session. I am taking the marathon for almost all the subjects, and the marathon the details are in the WhatsApp group. Please join the WhatsApp group. Whenever any update comes, I share it. There is a dedicated WhatsApp group for CS professional students. Vaishnavi, thank you so much for your patience and your kind words. Varun, thank you again. Do share with your friends and in your study circle. That's the my whatever request to you. Okay, how they say, please, we forever pray. We will be extremely happy. That's all. Thank you so much, guys. Have a great day. See you. Bye.